Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, let's unpack this. Imagine you've poured your heart and soul into a brilliant idea for an Indian tech startup, a true game changer.
Yeah.
You've envisioned the product, maybe even got a working prototype, and you can see that glimmer of potential that could disrupt an entire industry.
Right.
But then a crucial question surfaces, often when you least expect it. How do you actually protect that innovation? How do you ensure your genius isn't just copied, diluted, or worse, outright stolen before you even have a chance to get off the ground? That, for us today, is our mission. A deep dive into the essential intellectual property, or IP management roadmap, specifically tailored for Indian tech startups.
Yeah, and for so many founders, IP feels like this daunting, legalistic beast, something you just have to deal with way down the line, maybe once you've hit it big.
Right, like an afterthought almost.
Exactly. But that's a trap, and honestly, it can cost you everything. What's truly fascinating here is that IP isn't just about filing paperwork. It's about building a defensible, valuable asset from day one. It's an integral part of your business strategy that actually grows with your company. Our goal today is to give you a clear, phased roadmap, extracting the most important, actionable nuggets of knowledge to help you navigate this crucial journey right from the very beginning.
Absolutely. We're dissecting a fantastic roadmap designed to help a new Indian tech startup strategically identify, protect, monitor, and ultimately, monetize its intellectual property. And we'll show you how to leverage some incredible Indian government schemes and key global treaties to your advantage. Think of this as your shortcut to being well-informed on a topic that can genuinely make or break your startup. Throughout this deep dive, we'll break down the entire IP lifecycle, from that initial spark of an idea all the way to a successful exit, highlighting precisely what to do, when to do it, and critically, why each step truly matters.
And we won't just skim the surface. We've dedicated specific sections to each major type of IP. We're talking patents, trademarks, copyrights, trade secrets, and even industrial designs. We'll show you how they fit into each stage of your startup's growth. We'll unpack practical steps, give you some real-world timelines, and illuminate how you can tap into that incredible Indian government support and global mechanisms to protect your innovation effectively, turning legal requirements into, well, strategic advantages.
So let's set the scene. You've got an idea, perhaps a rough prototype, and you're in that exhilarating, maybe slightly chaotic 0 to 6 months window.
Yeah, the early days.
You're probably laser-focused on product development, finding market fit, maybe even sketching out your first fundraising deck. In that whirlwind, what's the absolute first thing a startup needs to consider regarding its intellectual property? Where do you even begin this journey?
Okay, so this initial phase, ideation and setup, it's less about formal filings right away and more about laying a really solid foundation. It's often overlooked, but it's absolutely critical. The very first step, even before your product is fully defined or your business plan is polished, is a thorough IP audit and classification.
Right.
You need to systematically identify and just list all potential IP assets your startup might possess or, create down the line. Think of it like taking an inventory of your innovation, not just your physical assets like laptops or desks.
An inventory of innovation. I like that. That sounds incredibly proactive.
Right.
So for a typical tech startup, what kind of things would actually make it onto that initial list? What are we looking for?
Well, it's actually far more encompassing than many founders realize. You're not just looking for that one big invention, that single patentable idea. Start with your core inventions, those novel ideas, unique algorithms, proprietary processes, maybe a new method of delivering a service. That's the obvious stuff. Then move to your brand elements. Your company name, the name of your app or product, your logo, any taglines or slogans you're developing. Next, creative works. The actual software code, your user interface. The UI designs any unique graphical elements, user manuals, internal documentation, even your marketing content like blog posts or videos. And finally, and this one's crucial, your confidential know-how. what we call trade secrets.
Ah, the secret sauce.
Exactly. This could be anything from a carefully curated client list, a specific data analysis model you've built, a unique manufacturing process if you're doing hardware, or even a particular recipe if you're in food tech. It's basically any secret information that gives you a competitive edge.
So it sounds like this initial audit isn't just about spotting the crown jewels, the big patentable tech, but also recognizing the sort of everyday elements that might hold unexpected value down the road.
That's a great way to put it. What's one common, seemingly minor IP asset that startups consistently overlook, only to regret it later?
Good question. I imagine maybe the specific look of their website, or maybe internal documentation.
Those are good examples, but a prime one is often the distinct visual appearance of their product itself, or maybe a unique icon set designed for their app. They might focus heavily on the underlying tech, the patent, or the brand name, the trademark,
Right.
but they forget that the actual look and feel, the industrial design, can be copied pretty easily. Or they overlook the specific creative expression in their marketing campaigns. These seemingly minor details, if they're unique, can also be protectable and later become a key differentiator. So that audit is invaluable for spotting everything. Once you've identified these potential assets, you then classify them. Helps you understand how to protect them. Patents, as you said, for those groundbreaking technologies. Trademarks protect your brand identity. Copyrights safeguard your creative expressions like code or design. And trade secrets protect that invaluable confidential know-how.
It really sounds like an IP audit done early is less about paperwork and much more about strategic foresight. I mean, if you don't even identify those assets, you can't protect them, let alone try and monetize them later on.
Precisely. It's the foundation of your intangible balance sheet, really. And right alongside that audit, you must establish clear IP ownership right from the get-go.
Okay, ownership, what does that entail exactly?
It means putting in place things like invention assignment agreements or employment agreements. These need to explicitly state that any intellectual property created by employees or contractors, in the course of their work for the company, actually belongs to the company.
Not the individual developer or designer?
Exactly. This ensures that the innovations developed by your team become the company's assets, not just owned by the individuals who create them.
I can instantly see how that would prevent massive headaches down the line. Imagine your star developer, let's call her Rena, creates this game-changing algorithm. A year later, she leaves, maybe starts her own company. If you don't have a crystal clear written invention assignment agreement, well, Rena could potentially claim ownership of that algorithm. And suddenly, your core tech is compromised. Your entire startup is at risk. So establishing IP ownership from day one in writing isn't just good practice. It sounds like it's your legal lifeline.
It absolutely is, and it's not just good practice, especially in India. An assignment of IP must be in writing to be legally valid. Verbal agreements, handshakes, they just won't cut it when it comes to something as critical as your startup's core assets.
Okay, so audit first, then lock down ownership in writing. That sounds like a lot to manage right from the start, particularly when cash is usually super tight for these nascent ventures.
Yeah.
What about resources and legal help? Do you really need a big legal team on day one?
No, definitely not a big team. But even in this very first phase, it's, let's say, prudent to allocate a small, dedicated IP budget. Think of it as a foundational investment, not just an expense you can slash if things get tight. And critically, you really need to engage a tech or IP consultant or a specialized lawyer early on.
Even in the first 6 months?
Yes. Their early advice on conducting those initial novelty searches for patents, clearance searches for trademarks, navigating the different types of filings, and importantly, drafting those crucial ownership agreements, it can prevent incredibly costly mistakes and disputes later. It's an investment that pays dividends by securing your future. And look, many IP professionals are used to working with startups. They often have cost-effective initial guidance packages, maybe a retainer basis, specifically for early-stage companies. They can help you prioritize where to spend those initial precious rupees.
Okay, let's dive deep into patents.
Yeah.
This is often seen as the ultimate badge of innovation, especially in tech. This is where you protect your truly unique inventions, your core algorithms, your novel processes, essentially, the bedrock of a deep tech company. How does this often intricate journey begin for an Indian tech startup, and how can they navigate it efficiently?
Right. Patents are about securing those exclusive rights to your novel technologies. It gives you a temporary monopoly on your invention for a specific period, usually 20 years from filing. And the roadmap here is incredibly strategic, starting much earlier than many founders might imagine. So we're still in phase one. Ideation setup, 6 months. Even before your product is fully developed, the first crucial step for any potential patent is to conduct preliminary patent novelty searches.
Novelty searches, what does that mean?
It means you need to search existing patents, scientific literature, public disclosures, basically anything out there to ensure your invention, or at least the key inventive aspects of it, appears genuinely new and non-obvious compared to what's already known. This existing knowledge is called prior art. This proactive step is crucial because it helps you avoid investing significant time and money into developing and trying to patent an invention that might later be invalidated because, well, someone else already thought of it or something very close.
So these preliminary searches are crucial for avoiding reinventing the wheel, essentially. But what if those searches reveal something too similar? What happens then? Do you just give up?
That's an excellent, very practical question. If your searches reveal something too similar, it's a critical decision point. You've got a few options. First, can you pivot? Can you innovate around that prior art to create something distinctly novel, maybe a different approach or a significant improvement?
Okay.
Second, is the prior art exactly what you've invented, making it unpatentable? If so, you actually save immense resources by not pursuing a patent that will inevitably be rejected.
And what if you proceed anyway, accidentally?
Legally, accidentally proceeding with an idea too close to existing prior art means your patent application would likely be rejected during examination. Or, even worse, if it somehow gets granted, it could be easily invalidated later in court, potentially exposing you to infringement claims if you're using a patented technology without a license. It's a really expensive lesson to learn post-launch. This early search is your shield. Now, if those searches come back positive, meaning your core invention seems truly novel and inventive and it's sufficiently well-defined, the very next critical action is to file a provisional patent application with the Indian Patent Office.
A provisional one, not the full thing.
Right, a provisional first. And this is paramount. You must do this before any public disclosure of your invention.
Public disclosure
Meaning things like pitching to investors without a rock-solid non-disclosure agreement, NDA, doing a demo at a conference, putting a detailed description on your website, or even publishing an academic paper about it. Once it's out there publicly without a prior filing, your novelty can be compromised, potentially barring you from getting a patent in many countries.
Okay, so get that provisional in before you talk about it. What does the provisional actually do for you?
It locks in a priority date. Think of it like staking your claim on a piece of land. It formally marks your place in line and establishes when your invention officially existed in the eyes of the Patent Office. This first-to-file principle is crucial globally.
Got it.
The beauty of a provisional application is that it's less formal and significantly less expensive than a full patent application. It often just needs a detailed description of your invention, how it works, what it does. It doesn't require all the complex legal claims and formal drawings right up front, but it gives you that critical priority date.
So the provisional patent isn't just a technicality. It's almost like a strategic pause button.
Yeah.
It buys you time without losing your place in line.
Exactly. It buys you 12 months from that priority filing date. During that year, you can refine your invention, conduct further R&D, gather more data, maybe test the market a bit. And crucially, within those 12 months, you need to submit a complete patent application. This 12-month window is granted under the Paris Convention, an international treaty. It allows you to file subsequent applications in other member countries within that period, still claiming the benefit of your initial Indian priority date. It's a strategic grace period that lets you develop your invention further before committing to the full expense and detail of a complete application in India and potentially abroad. It's a real lifeline for lean startups.
Okay, now, moving into phase 2. Product development and Indian protection. 6-18 months. That 12-month Paris deadline starts looming.
Right, the clock is ticking. This is when you must convert your provisional filings into complete patent applications at the Indian Patent Office. Or, if new inventions have popped up during development, you file entirely new, complete applications for those. A complete application is much more detailed. It requires a full specification, meticulously drafted claims that define the legal scope of your invention, a comprehensive description, and clear technical drawings.
This sounds like where the serious legal drafting comes in. It's not just a quick summary like the provisional, right?
Yeah.
It feels like the quality of that drafting those claims especially could make or break the strength of the patent itself.
You've hit on a critical point. The quality of this drafting is absolutely crucial. A poorly drafted patent with weak or narrow claims can be easily challenged, limited in scope, or even easily circumvented by competitors. They can design around it. This is why we strongly recommend using a registered patent agent or attorney for this. Their expertise ensures your claims are broad enough to provide meaningful protection while still being novel, non-obvious, and clearly supported by your description. It's really an art and a science, ensuring every word serves to define and defend your innovation effectively. And here's where Indian startups have a significant, almost transformative advantage. If your startup is recognized by DPIT, that's the Department for Promotion of Industry and Internal Trade, you can apply for expedited examination under the Startup India Fast Track program.
Expedited examination. That sounds like a dream for a fast-moving startup, where speed to market is everything. What's the real tangible impact of that? Is it just getting the patent faster?
It's much more than just getting it faster, although that's a huge part of it. The impact is substantial, and it directly influences your competitive landscape and even your fundraising ability. This expedited route can significantly speed up the patent grant process. Often, DPIIT-recognized startups can secure a patent grant within approximately 1 year, maybe even less in some cases.
1 year. Compared to what normally?
Compared to standard timelines that can easily stretch much longer, sometimes 3, 4, even 5 years or more in India.
Wow.
Think about it. In the startup world, a year feels like a decade. Imagine launching your product knowing your core innovation is not just patent pending, but likely to be granted within months, while your competitor might still be years away from securing anything.
That's a huge head start.
It's not just an advantage, it's practically a superpower. It gives you critical lead time for fundraising. Investors love granted patents, market dominance, and deterring early infringers. We've definitely seen startups successfully secure grants in around 12 months using this route. Now, during this phase, and really throughout your entire R&D process, it's also vital to document everything. Maintain meticulous R&D records.
Like what specifically? Lab notebooks.
Yes, exactly. Lab notebooks if you're doing hardware or biotech. For software, think version control logs with clear comments, design documents, internal memos, meeting minutes discussing the invention, even emails, and ensure all entries are meticulously dated. Who invented what, when, and how.
Why is that level of detail so paramount? I imagine founders are often just focused on building, not record keeping.
Because these meticulous records are your battle armor. They are vital proof of your invention timelines. If you ever face an infringement challenge, need to assert your patent rights in court, or find yourself in a dispute over inventorship, who actually came up with the idea, these records are invaluable evidence. They can establish precisely when you conceived the idea, when you reduced it to practice, built a working version, and demonstrate diligence. This can be critical in litigation or disputes, especially in a first-to-file system like India's. Without clear documentation, your claims can easily be undermined. And just a quick update on that budget and counsel point for this phase. While attorney fees for drafting those complete applications are still a significant factor, the actual Indian filing fees for recognized startups are surprisingly small after the rebates, often ranging from around $1,500 to maybe $4,000 for a patent.
That's incredibly low for government fees.
It is. It drastically reduces the statutory cost barrier to protecting your innovation domestically, making it much more accessible for even bootstrapped startups.
Okay, so you've navigated phase 1 and 2.
Right.
You've got your provisional filed, hopefully converted to a complete application in India, maybe even under expedited review, thanks to DPIIT. Your sights are likely set on bigger markets now. The world is your oyster, as they say. How do you protect your patents globally? Because, as you said, a patent granted in India doesn't automatically protect you in the US or Europe, right?
That's absolutely right. A patent is jurisdictional, meaning it's only valid in the country that granted it. So this is where things get really strategic. We're now looking at phase 3, international expansion and protection, roughly 18 to 36 months from your first filing. The first step here is crucial market analysis. You need to identify your key target markets.
And that's not just where you want to sell.
No, it's more strategic than that. It's where you plan to sell, yes, but also where your major competitors are operating, where your technology might have the most significant market value, where potential manufacturing might happen, and where you might seek partners or licensees down the road. Typically, top choices for tech include the U.S. through the USPTO, the European Union, often via the European Patent Office or EPO, which covers many countries, China, CNIPA, Japan, JPO, and South Korea, KPO. Maybe some others depending on your specific industry.
Why those specific ones?
Because these 5 jurisdictions alone account for something like 89% of global patent filings. If you're not considering filing there, you're effectively ignoring where the vast majority of the serious IP game is played and won.
Wow, 89%. That really underscores the strategic importance of those markets. So once you've identified those key markets, how do you actually go about filing internationally without completely breath in the bank? It sounds expensive.
It can be, which is why strategy is key. This is where the brilliant PCT route using the Patent Cooperation Treaty comes into play. Ideally, by month 12 from your very first Indian filing date, that same deadline we talked about for the Paris Convention, you should file a PCT application. You can file this through the Indian Patent Office itself or directly through WIPO, the World Intellectual Property Organization in Geneva.
Okay, the PCT. What's the big advantage? Does it give you like a single global patent? I hear that term thrown around.
That's a common misconception. The PCT is a game changer, but it's important to clarify. It does not grant a global patent. There's no such thing. Instead, what a single PCT application does is it preserves your priority date in approximately 150 member states. So almost everywhere that matters. And critically, it effectively defers the need to file and pay for individual national applications for an extended period.
So it buys you more time.
Exactly. It also provides an initial international search report and often a preliminary examination report. These give you valuable insight into the potential patentability of your invention on a global scale before you commit to significant costs in multiple countries. Most importantly, the PCT generally gives you until month 30 or 31 from your original priority date to enter the national phase.
30 months, that's 2.5 years from the initial filing.
Correct. This buys you crucial time over 2 years from your first filing to further assess international patentability based on the search report, refine your business strategy, maybe secure funding, and make informed decisions about which specific countries you truly want and need to pursue protection in before spending the big money on those individual national filings and translations. It's a strategic delay tactic that empowers startups with limited cash flow. So around that month 30-31 deadline, you then enter the national phases in your chosen key offices. This means filing individual patent applications, often based on your PCT application, in places like the USPTO for the US, the EPO for Europe, CNP for China, JPO for Japan, KIPO for Korea, and perhaps others like WIPO for GCC countries like the UAE.
So the PCT buys you time and information, helping you decide where to focus resources, but ultimately you still need to file and prosecute the application in each country or region you want protection in. It sounds like you're playing chess with your IP strategy, thinking several moves ahead.
Exactly right. The PCT is a procedural umbrella, a fantastic tool for streamlining the initial process and deferring costs. But ultimately, the national or regional patent offices grant the actual patents based on their own laws. Now, as an alternative, if you have significant funding early on and are absolutely certain about 1 or 2 critical jurisdictions from day one, say the US and China, you could choose to direct file earlier in those countries under the Paris Convention within that initial 12-month window from your first Indian filing.
Bypassing the PCT for those specific countries.
Yes. But for most startups, the PCT route is far more practical and cost-effective, allowing for more informed decisions later when you have more data and potentially more funding. And throughout this international filing process, always remember that Paris Convention priority. We keep mentioning it because it's fundamental. That treaty gives you 12 months for patents and 6 months for designs and trademarks to file abroad from your first filing date without losing that original priority. This is critical because it protects you against any intervening public disclosures you might have made after your first Indian filing, but before your international filings under PCT or Paris. And of course, once you start expanding internationally, you need to think about setting up IP watch services.
Watching for what?
Watching for potential infringers or competitors. This involves utilizing patent databases and specialized services to track similar patent filings in your target markets that might infringe on your turf, or even just indicate a competitor is working in a very similar area. It's about proactive vigilance, knowing what's happening around you.
Okay, makes sense. So fast forward a bit. You've successfully built your patent portfolio, maybe got grants in India and key international markets, and your startup is growing. Now what? How do you keep that portfolio valuable, defend it against challenges, and actually leverage it to generate revenue or attract more investment? It's not just about getting the certificate right.
Absolutely not. Now we enter phase 4. Growth, enforcement, and exit strategy, roughly 36+ months. This is where it's all about maintenance, vigilance, and actively leveraging your hard-won assets. First, portfolio maintenance is non-negotiable. You must keep a strict docketing system.
Docketing.
Yeah, basically a calendar or database tracking all critical deadlines, especially patent annuity payments. These are fees paid periodically, often annually, to the patent offices just to keep a granted patent in force.
Ah, so you have to keep paying even after it's granted.
Yes. And missed renewals mean your patent rights lapse. All that effort and investment goes completely to waste. It's heartbreaking, but happens surprisingly often due to poor docketing or budget oversight.
Okay, so keep paying the bills.
Yeah.
What else?
Next, monitoring and infringement. You need to continuously monitor the market and the internet for any unauthorized use of your patented technology. This isn't just passive waiting. It involves active watch services, targeted online searches, monitoring competitor activities and product launches, sometimes even reverse engineering competitor products to see if they're using your tech. If infringement is detected, you must pursue enforcement actions promptly. Delay can sometimes weaken your case.
And what does enforcement look like in India?
In India, it typically starts with sending a formal cease and desist letter to the infringer demanding they stop. If that doesn't resolve it, you can apply for civil relief like injunctions to stop them and damages for your losses in the district courts or high courts. Many high courts now have specialized IP benches or judges to handle these complex cases more efficiently. Additionally, for issues involving infringing goods being imported, you can leverage border enforcement. You record your patents with the Indian Customs under Section 11 of the Customs Act. This allows customs officials to potentially seize imported goods at the border that infringe upon your registered IP rights. Imagine a competitor trying to import knockoff versions of your patented drone technology. Customs can potentially stop it right there.
That sounds powerful. But patents aren't just for defense, are they? You mentioned leveraging them. How do they become tools for growth and revenue?
Right. They are powerful tools for licensing and revenue. This is where patents become true financial assets for monetization, not just shields.
So it's not just about protecting your own use, but potentially letting others use your invention too, for a fee. That sounds like a powerful way to expand your reach or generate income without building everything yourself.
Precisely. You can explore licensing your patents and related technology to other companies. This could be for upfront fees, ongoing royalties based on their sales of products using your tech, or often a combination. Patents are also incredibly valuable in structuring joint ventures or partnerships. A common strategy is cross-licensing deals, where two companies, maybe even competitors, agree to let each other use certain patents. This can be done to avoid costly litigation or to gain access to complementary technologies needed for their own products. Think about smartphone manufacturers. They often cross-license heavily to avoid constant patent wars.
Makes sense. Any other ways to monetize?
Yes. In certain standard-setting industries, think telecommunications, like 5G standards, or video compression standards, you can consider contributing your essential patents to patent pools and standards organizations. If your patent becomes part of an industry standard that others must use, you can generate significant licensing revenue as companies need to license these pooled patents to comply. It effectively turns your defensive asset into a potentially consistent revenue stream where your innovation becomes part of a larger technological ecosystem. Your patent portfolio also plays a crucial role in fundraising and partnerships. When you're pitching to investors, especially venture capitalists, make sure to highlight your robust patent portfolio.
Why do they care so much?
Because it signals defensibility, a barrier to entry for competitors, genuine innovation, and a long-term competitive advantage, all things highly valued by investors looking for scalable businesses. Granted patents lend significant credibility to your startup, showing you're not just building a product, but a protected, valuable technological asset. Finally, when it comes to an exit strategy like a merger and acquisition (M&A) or an initial public offering (IPO), you absolutely must perform a thorough IP audit beforehand to clean up, organize, and value your portfolio. Good, well-maintained IP records significantly increase your company's valuation. Potential acquirers or underwriters will scrutinize your IP. Patents can even be spun off and sold as standalone assets or used as collateral for certain types of financing. They are core intangible assets that can attract strategic partners or improve negotiation terms significantly. A strong patent portfolio is a massive part of the company's overall value at exit. One final point to just be aware of, though it's quite rare outside highly regulated fields like pharmaceuticals, is the theoretical risk of compulsory licensing. This is where a government might mandate that you license your patent to a third party, even if you don't want to, usually under very specific public interest circumstances, like a national emergency or a critical public health need. But again, for most tech startups, this is generally not a significant day-to-day concern.
Okay, moving on from the tech itself. Your brand. It's everything, isn't it? It's how customers recognize you, how they connect with your product emotionally, and it embodies your reputation in the marketplace. It's really the face of your startup. How do founders ensure their hard-earned brand names, logos, slogans are protected against imitators or copycats?
You're absolutely right. Trademarks are your brand's shield. They protect those distinguishing elements, names, logos, slogans, sometimes even sounds or colors that differentiate your goods or services from others in the marketplace. They build recognition, trust, and ultimately brand loyalty. So, back in phase one, ideation and setup, 0 to 6 months. Your initial IP audit and classification will naturally identify your core brand elements. The name you're thinking for your startup, your app's name, your logo design, maybe that catchy slogan you came up with. But before you get too attached to that brilliant name you love, the next step is absolutely crucial. Preliminary trademark clearance searches.
Oh, clearance searches. That sounds similar to the novelty search for patents.
It is similar in principle, yes. You need to perform these searches early, before investing in branding or filing, to ensure your chosen brand elements aren't already registered or being used by someone else, especially in your industry or a related field. You check the official trademark databases.
So it's like checking if your chosen domain name is available, but for your entire brand identity, and with much higher legal stakes. What's the real consequence if you skip this step and, oops, pick a name that's already taken, or confusingly similar?
Exactly, and the stakes are far higher than just a domain name. If you skip this crucial search, you risk a potentially devastating, costly, and emotionally draining rebranding exercise down the line.
Rebranding, that sounds like a nightmare.
It is. Imagine building an entire brand identity website, marketing campaigns, product packaging, customer loyalty all around a name, only to receive a cease and desist letter from another company claiming you're infringing on their established trademark rights. You'd likely have to scrap everything, redesign logos, change your name, relaunch marketing, maybe pull products, and potentially face legal action seeking damages. It can be a significant, even fatal setback for a young company trying to gain traction. And speaking of digital identity, you should also immediately register domain names and relevant social media handles that match your chosen brand, assuming the clearance search looks good.
Why immediately?
To prevent cyber squatting, where someone registers your desired domain name hoping to sell it back to you at an inflated price, or just to stop others from grabbing your digital identity before you can, which can dilute your brand presence and confuse your potential customers. Secure that digital real estate early. Okay, so once you've done your due diligence with the search and settled on your brand elements, it's time for initial filings. As soon as your startup name or logo is chosen and cleared, file a trademark application in India using Form TMA with the Trademark Registry.
Even before the official product launch.
Yes, absolutely. You should do this even before your official launch to secure your rights. The earlier you file, the stronger your claim. Trademark rights in India are generally established by either first use in commerce or by first to file. Filing secures that crucial priority date for you, even if you haven't started selling yet but have a clear intent to use the mark. And here's another significant benefit for Indian tech startups. If you have that DPIIT recognition, you get a 50% fee rebate on your trademark application fees. This makes it much more affordable to establish your brand's legal protection right from the very start. Okay, moving into phase two. Product development and Indian protection, 6 to 18 months. The Indian trademark registration process begins to unfold after you file that Form TMA. The Indian Trademark Registry will conduct its own examination, which includes a search for conflicting marks. If it passes that, it then publishes your mark in the official trademark journal.
Why publish it?
This publication period allows third parties, maybe competitors or other brand owners, about 4 months to oppose your registration if they believe it conflicts with their own prior rights. You need to be prepared to respond to any examination objections the registry might raise, often related to the mark's distinctiveness or similarity to existing marks, and also potentially defend against oppositions.
And what's the typical timeline for getting a trademark officially registered in India, assuming, everything goes smoothly, no major oppositions?
If it's unopposed and you address any examiner queries promptly and effectively, a trademark typically registers in India within 6 to 12 months. Sometimes a bit longer, but that's a reasonable time frame. A critical strategic detail here, though, is to ensure your application covers all relevant NICE classes.
NICE classes, what are those?
These are international classifications of goods and services under the NICE agreement. There are 45 classes in total. For a tech startup, for instance, you'd almost certainly register under Class 9 for software, downloadable applications, etc. But depending on what you do, you might also need Class 35 for business services like advertising, data processing, or retail services. Or Class 42 for software as a service, SaaS, platform as a service, IT consultancy or R&D services.
So you need to pick the right categories for what you actually do.
Exactly. You need to accurately describe your goods and services and file in all the classes relevant to your current and planned business activities. Covering all your bases correctly is essential to ensure comprehensive protection. Filing too narrowly might leave parts of your business exposed. And again, just to reiterate the Startup India IP benefits, beyond that 50% fee rebate for DPI IT recognized startups, you can also leverage those government-appointed IP facilitators through the SIPP scheme. They can handle the drafting and filing of your trademark applications, often meaning the startup only pays the heavily rebated statutory fees. This significantly eases the administrative burden and the professional costs, allowing founders to focus on building the actual product and business.
Okay, so you're building a strong brand in India, your trademark is registered or well on its way, and now you're thinking bigger global expansion. How do you extend that vital trademark protection beyond India's borders without having to navigate a potentially complex maze of different legal systems and filing requirements in every single country you want to sell in?
Right. This is where we move into phase 3, international expansion and protection, 1836 months for trademarks. And similar to patents, there's a very powerful international system, the Madrid Protocol.
The Madrid system. That sounds like another potential global shortcut, like the PCT for patents. Tell us more about how it works and its real utility for a startup.
It is indeed a fantastic tool. The Madrid system, administered by WIPO, allows you, once you have your Indian trademark application filed or registered, that's your basic mark, to file a single international application through WIPO. In this single application, you designate the specific Madrid member countries where you want protection. This could include key markets like the US, the European Union, as a single designation covering all EU member states via EU IPO, China, Japan, Korea, Australia, UK, and even GCC members like the UAE, Oman, or Saudi Arabia who have joined recently.
So one application, filed centrally, can cover potentially dozens of countries. That sounds much simpler and probably cheaper than filing individually everywhere.
Absolutely. The Madrid system currently covers approximately 131 countries, offering incredible reach and efficiency. You pay one set of basic fees to WIPO, though individual country fees also apply, and one centralized process handles the initial application formalities and forwarding it to all your designated countries. However, there's a crucial point. Just like the PCT, Madrid is a filing mechanism, not a granting one. Your international trademark application then undergoes substantive examination according to the national laws and procedures of each designated country's trademark office.
So while the filing is centralized, the granting of protection is still local, country by country.
Correct. But the system dramatically reduces the initial administrative burden, paperwork, and costs compared to filing separate national applications directly in each country, especially regarding translations and local agent fees initially. Also, remember the Paris Convention priority for trademarks. You have 6 months, unlike the 12 for patents, from your first Indian filing date to file abroad, including via Madrid, without losing that initial priority date. This offers protection against any intervening public disclosures or competing applications filed during that 6-month window. As your company grows and potentially introduces new product lines, maybe sub-brands, or enters completely new market segments, ensure you also undertake IP portfolio expansion for your trademarks. You might need to file new applications to cover these new offerings or the classes they fall into. Otherwise, your new products might not be protected by your original marks.
Right, your protection needs to evolve with the business.
Exactly. And just as with patents, setting up IP watch services internationally is vital for trademarks too. Services like WIPO's Madrid Monitor or commercial providers like Corsair can monitor new trademark applications filed worldwide that might conflict with or infringe on your brand. This helps you stay ahead of potential issues and oppositions. Finally, proactive legal preparation is key for international brand expansion. Engage local IP counsel or agents in your key target countries early on. They can advise on local nuances, handle the examination process after the Madrid filing, and be ready for potential future enforcement. And it's often wise to formally register your company name and trademarks in those jurisdictions to prevent third parties from trademark squatting, registering your mark defensively just to block your entry or try and extort payment from you later. Okay, moving into phase 4. Growth, enforcement, and exit strategy, 36 plus months for trademarks. It's about continued vigilance and actively leveraging your brand equity. First, portfolio maintenance is critical. Trademarks need to be renewed periodically to stay in force. In India and many other countries, this renewal is typically required every 10 years. You absolutely must keep strict track of these deadlines to avoid inadvertently losing your valuable brand rights.
10 years. That's a longer term than patent annuities, but still something you need to track carefully.
Definitely. Missing a renewal can lead to the loss of your brand's legal protection, which could be catastrophic. Then there's constant monitoring and infringement. You need to continuously monitor the market, the internet, social media, and popular e-commerce platforms for any unauthorized use, counterfeiting, or blatant imitation of your brand. Tools and services exist specifically for this, often using AI to scan for visual logo or textual brand name infringements online.
And if you do find someone using your brand unlawfully, maybe selling counterfeit versions of your product online, or using your logo on a scam website, what are the immediate steps you can take?
You take enforcement actions. In India, you typically start by sending formal cease and desist letters. If that doesn't work, you can pursue civil relief in the courts, seeking injunctions to stop the infringing activity and potentially claiming damages for the harm caused to your brand and business. For more serious issues like outright counterfeiting or piracy, criminal complaints can also be filed under relevant sections of the Indian Penal Code or the Trademarks Act, which can carry more severe penalties, including fines and imprisonment.
Okay, and what about online infringement? That seems rampant.
Online, the primary mechanisms are often takedown notices. For infringing content or product listings on platforms, you can use mechanisms like the DMCA, the Digital Millennium Copyright Act in the US, which can apply to trademark-related content too, or more commonly, the specific IP reporting procedures provided by various platforms like Amazon, Flipkart, Google Play, the Apple App Store, Facebook, Instagram, etc. They usually have dedicated portals for reporting infringement, and again, border enforcement is an option. Recording your registered trademarks with Indian Customs can help them identify and seize imported counterfeit or infringing goods before they even enter the Indian market. You can also look into more advanced brand protection strategies. For really famous brands, there's the possibility of seeking official registration as a well-known mark under national laws or Article 6Bs of the Paris Convention via WIPO. This offers broader protection, potentially blocking the misuse of your logos and emblems in other countries, even across different classes of goods or services, because the mark's reputation transcends specific product categories or borders. Your trademark portfolio is also a valuable asset for licensing and revenue. You can strategically license your brand, the name, the logo for use on related product lines, merchandise, or even to other companies in different sectors to expand your market reach and generate additional revenue through royalties without direct investment in those areas. Think of a popular software brand licensing its name for apparel or accessories.
Right. Leverage the brand equity.
Exactly. When it comes to fundraising and partnerships, a strong portfolio of registered trademarks significantly signals credibility, market presence, and defensibility to investors and potential partners. It shows you've protected a key asset that consumers recognize and trust, which reduces risk for them. And naturally, in an exit strategy like M&A or IPO, strong, well-protected brands are incredibly valuable assets. They directly contribute to the company's valuation, often making up a significant portion of its intangible worth. A recognizable, protected brand is something acquirers pay a premium for.
Okay, we're living in such a digital world now where code, content, creative designs, these are absolutely central to the value proposition of so many tech startups. Whether it's the sleek UI of an app, the innovative software architecture behind it, or the compelling marketing materials they create, how do you protect these creative expressions that seem so easily copied and disseminated online?
Yeah, that's where copyrights come in. Copyrights are specifically designed to protect original works of authorship fixed in a tangible medium. For tech startups, this crucially includes things like your software source code and object code, the specific graphical elements and layout of your user interface, UI, your user manuals and documentation, website design and content, marketing materials like brochures or videos, blog posts, and even the original databases you might compile. Now, back in phase 1, ideation and setup, 0-6 months. During your initial IP audit and classification, you'll identify these creative works alongside patents and trademarks. But here's a key difference with copyrights compared to the others we've discussed. The Berne Convention.
The Berne Convention, what's that?
It's a major international treaty, and India, the US, Europe, almost every major country is a signatory. It dictates that copyright protection vests automatically upon creation globally as soon as the work is fixed in a tangible form.
Automatically. So if I write a piece of code for my app or design a unique icon set for the UI, it's immediately copyrighted the moment I save the file. I don't actually need to file anything with the government for the copyright to exist.
Exactly. That's the core principle of burn. The moment you fix your creative work in a tangible form, write the code, draw the UI, compose the text, record the audio copyright automatically exists in that work. There are generally no formalities like registration required for the protection itself to arise and be recognized internationally.
Wow. That's quite a different mechanism from patents and trademarks, where filing is absolutely paramount to get rights.
It is. However, while registration isn't required for copyright to exist, for stronger evidence in potential disputes, it's still often a very good practice to consider depositing copies of your significant creative works with the Indian Copyright Office. You can file form-free along with copies of the work.
Why bother if it's automatic?
Because registration creates a public official record of your claim to ownership and the date of creation. This certificate of registration can be immensely helpful if you ever need to prove your ownership in court during an infringement lawsuit. It provides what's called prima facie evidence of validity and ownership, shifting the burden of proof to the alleged infringer. It simplifies enforcement significantly. But perhaps the most practical and universal best practice, regardless of registration, is simply to keep well-dated backups of all your code, artwork, content, and documentation.
Just good backups.
Yes. This simple measure, coupled with using version control systems like Git for software development, which automatically logs changes and dates, can provide compelling evidence of creation dates and ownership if you ever need to prove it. Those digital timestamps on files and commit logs can be surprisingly powerful evidence in a dispute. Okay, moving into phase 2. Product development and Indian protection, 6 to 18 months. That copyright registration step, as we discussed, is still optional but highly recommended for your most significant creative assets. This might include your core software application, key user manuals, unique graphical libraries, maybe your main marketing videos or website template.
And what's the actual process for filing for registration like in India? Is it a lengthy, complex, bureaucratic endeavor or relatively straightforward compared to patents?
It's generally quite straightforward, much less complex and less expensive than patent prosecution. You can file online via the official portal, copyright.gov.in. You submit Form 4, the requisite fee, which is quite low, and copies of the work being registered, for example, source code printouts, design files. The primary benefit, again, of this optional registration is creating that public, government-stamped record of your ownership. This can be incredibly helpful in deterring potential infringers, you can use the he symbol more effectively, and simplifying any potential disputes or litigation by providing clear, undeniable evidence of your claim. While not required for copyright to exist, it makes proving and enforcing that ownership significantly easier, especially in a courtroom. During this phase, it's also crucial, as always, to document everything related to your creative works, maintaining those detailed version control logs with dates for all code, design files, content updates. This provides a clear chronological history of creation and modification, which, again, is invaluable in proving ownership, originality, and demonstrating independent creation if you ever face an infringement claim. Now, when we talk about Phase 3, International Expansion and Protection, 1836 months for copyrights, the Burnett Convention truly shines again, because all major markets, the US, EU, China, Japan, Korea, etc., are members of the Burnett Convention, your copyrights. Whether it's software code, written content, music, graphics, they are protected automatically in those countries without needing any formal registration abroad.
That's a huge relief, honestly, especially after hearing about all the complexities and costs of international patent and trademark filings. So I don't actually need to go and register my software code separately in every single country I operate in just to have it legally protected there.
That's correct, generally speaking. The principle of national treatment under Burnett means your Indian-created copyright is recognized and protected in other Burnett member countries just as if it were created there, according to their local laws. Your code is protected the moment it's written and saved, enforceable in those countries. However, there's a small but important note regarding enforcement. While no formalities are needed abroad for protection to exist, for stronger legal standing in an actual dispute or lawsuit in certain countries, most notably the US, it may be advantageous or even necessary to register the copyright in that specific country. US law, for example, generally requires US registration before you can file an infringement lawsuit in federal court, and to be eligible for certain remedies like statutory damages and attorney's fees.
Ah, okay. So protection is automatic, but enforcement might be easier or stronger with local registration in some key places.
Precisely. So, while not a prerequisite for protection itself, like patents or trademarks, you might strategically decide to register your most critical copyrights in key markets, like the US, if you anticipate needing to enforce them there. But it's not an automatic requirement everywhere just for protection to exist. Finally, in Phase 4, growth, enforcement, and exit strategy, 36 plus months for copyrights, you shift focus to monitoring and leveraging these creative assets. Monitoring and infringement involve continuously scanning the internet for unauthorized use or copying of your software, content, or designs.
How do you even do that? The internet is vast.
For code, you can use specialized code search tools or even just strategically use public platforms like GitHub search functionality to see if significant chunks of your proprietary code have been openly copied or illegally distributed in other projects. For text content, plagiarism detection tools can help. For images or videos, reverse image searches or specific monitoring services exist. If you find infringement, you take enforcement actions. In India, you can pursue civil relief, injunctions, damages, or, in cases of commercial-scale piracy, potentially file criminal complaints. Online, the primary mechanism globally is often those takedown notices.
Like the DMCA.
Exactly. Sending GMCA takedown notices to internet service providers, hosting companies, search engines, or platforms hosting the infringing content is often the quickest way to get it removed in the US and many other regions that follow similar procedures. Most major platforms, app stores, social media, content sites like YouTube also have their own specific procedures for reporting copyright infringement. And like other IP types, you can also leverage border enforcement by recording your key copyrights with Indian customs to help them seize imported infringing physical goods, such as pirated software on disks or counterfeit books or manuals. Copyrights are also ripe for exploitation and monetization. You can generate revenue directly from your copyrighted software or content through various models: direct sales, subscriptions, SAGs, advertising revenue on content platforms, or by granting licenses for royalties.
Licensing code.
Sure. You could license specific software libraries you've developed or maybe your UI framework. If your startup creates unique sound libraries, stock photos, or music for apps, you might consider joining collective management organizations, CMOs, that handle licensing and royalty collection on your behalf, ensuring you get paid when your work is used by others. Or, if you've developed an innovative AI model that generates creative content, you can license the output or the model itself. And a very, very important consideration specifically for tech startups is managing open source software, OSS.
Yes, almost every tech company uses open source code these days.
Exactly. And while OSS is fantastic for accelerating development, it comes with license obligations. If your startup incorporates OSS into its products, which is extremely common, you must diligently understand and comply with the specific licenses attached to each OSS component you use.
Why is that so critical?
Because different OSS licenses have vastly different requirements. Some are very permissive, like MIT or BSD licenses, only requiring attribution. But others, known as copyleft licenses, like the GPL family, can have more stringent obligations. For instance, some might require you to make the source code of your own proprietary software publicly available if you distribute it linked with that copyleft OSS component.
Wow, so using the wrong type of open source could force you to give away your own secret code.
Potentially, yes, under certain circumstances and specific licenses. Mismanaging OSS licenses can lead to serious IP contamination issues, unexpected obligations to open source your own valuable proprietary code, or breaches of contract with your customers. This can be devastating for a commercial software product that relies on keeping its core technology proprietary. A thorough OSS audit and compliance policy is absolutely critical for any tech startup.
Okay, we've talked extensively about the publicly registered forms of intellectual property. Patents for inventions, trademarks for brands, copyrights for creative works, and we'll get to designs. But not all valuable information is meant for public registration. In fact, some of your most important assets might be secrets, the hidden gems, the secret sauce that gives you your true competitive edge. How do you keep those under wraps when they're not protected by any public registry?
You're absolutely right. Trade secrets are often the hidden jewels in a company's IP portfolio. They encompass confidential business information that provides a significant competitive advantage, precisely because it's kept secret from competitors. Think of things like highly specialized customer lists or pricing strategies, unique marketing plans, proprietary algorithms that might not meet the strict criteria for patentability or that you strategically choose not to patent, novel manufacturing processes or formulas, results of internal R&D that failed but taught you valuable lessons, or even the secret recipe for a specific flavor profile in a food tech startup, like the classic Coke formula example. Their value lies entirely in their secrecy. Now, in phase 1, ideation and setup, 0 to 6 months, your initial IP audit and classification should explicitly identify these critical confidential assets. What information gives you an edge because others don't know it? Once identified, the next step is paramount because there's no government office to file with. It's all about implementing secrecy measures. This is your first and main line of defense.
So it's less about filing forms and entirely about proactive internal company practices, right? What are some concrete examples of those essential secrecy measures, beyond just telling people don't share?
Exactly. It's all about actively managing and protecting the information internally and being able to prove you took reasonable steps to keep it secret. The cornerstone is implementing strict non-disclosure agreements, NDAs. You need these signed by everyone who might potentially come into contact with your sensitive information. That includes all employees, contractors, interns, potential business partners, suppliers, even investors during due diligence or early pitches. These legally binding contracts explicitly prohibit them from disclosing or misusing your confidential information. Without robust, well-drafted NDAs in place, your claim that information was a trade secret is significantly weakened if it leaks.
Okay, NDAs are key. What
Right.
else?
Beyond the legal contracts, you need to enforce stringent confidentiality practices throughout your entire organization, building a culture of secrecy around critical information. This includes practical steps like implementing strong password policies and multi-factor authentication, limiting access to sensitive data strictly on a need-to-know basis. Not everyone needs access to everything. Using secure internal systems with robust firewalls and encryption for critical data, both at rest and in transit.
Physical security, too.
Yes, absolutely. Physical security measures for sensitive documents or prototypes, like locked cabinets or restricted access areas, secure disposal of sensitive documents, shredding, clear labeling of documents as confidential. And importantly, conducting regular employee training on confidentiality protocols and the importance of protecting trade secrets. The whole company culture should reinforce why keeping these secrets safe is vital to the business's success. Think about how famously secretive companies like Google or Apple protect their core algorithms or future product designs. It's a multi-layered fortress of internal controls, technology, and legal agreements, not just a single NDA. Now, a very important point specifically in the Indian context. As of now, India currently lacks a dedicated, standalone trade secrets law. While a bill was proposed back in 2016 and there's ongoing discussion, it hasn't been enacted into a specific statute like the Patent Act or Trademarks Act.
So how are trade secrets protected in India, then, legally?
Protection primarily comes from enforcing those well-drafted contracts, like NDAs and employment agreements, and relying on established common law principles. This includes legal actions based on breach of confidence, breach of contract, inducement to breach contract, or general principles of equity and unfair competition. This lack of a specific statute makes having those robust contractual agreements and being able to demonstrate your active efforts to maintain secrecy even more critical for Indian startups, as you rely heavily on these elements to seek legal recourse if your trade secrets are misappropriated. Now, skipping ahead to phase 4. Growth, enforcement, and exit strategy, 36 plus months, for trade secrets. Should a trade secret ever be misappropriated, maybe an employee leaves and takes your customer list to a competitor, or a partner misuses your confidential algorithm, your ability to litigate successfully hinges heavily on your ability to provide clear document evidence.
Evidence of what exactly?
Evidence proving 3 key things. 1, that the information actually qualifies as a trade secret. It's confidential, valuable because it's secret and not generally known. 2, that you took reasonable steps to protect its secrecy, those NDAs, security measures, access controls we discussed. And 3, that the defendant acquired, used, or disclosed it improperly, example, in breach of an NDA or through industrial espionage. So it's crucial to have clear logs and documentation. This could include access logs to restricted databases or servers, records of who attended confidentiality training sessions, copies of all signed NDAs, version histories of the secret algorithm or process, documentation showing the value derived from the secret. This evidence is absolutely vital if you need to go to court to prove your case. Without it, it's very hard to win a trade secret misappropriation claim.
So to sum up for trade secrets, it's completely different from the others. No public registration. It's entirely about proactive internal measures, ironclad contracts, meticulous, provable documentation of your protection efforts, and maintaining that secrecy vigilantly. It's a continuous internal battle.
Precisely. A trade secret is only a secret, and thus only a legally protectable asset, if you consistently and actively treat it like one and can prove you did so. Diligence in maintaining secrecy is your only real shield here.
Okay, we've covered the core tech with patents, The brand with trademarks, the creative works with copyright, and the hidden know-how with trade secrets. All incredibly important for a tech startup. But what about the actual look and feel of your product? The visual appeal, the unique shape of a physical device, or maybe the distinctive layout of a graphical user interface? Does that count as IP, and how do you protect it in a market where aesthetics often play a huge role in driving consumer choice?
Absolutely. You're hitting on another distinct category of IP. If your product has unique visual features, aesthetic aspects that contribute significantly to its commercial appeal, then industrial designs come into play. This form of IP specifically protects the aesthetics, the overall visual appearance. It covers elements like the shape, the configuration, how parts are arranged, the surface pattern, the ornamentation, or the composition of lines or colors applied to an article, provided these features are new or original and appeal to the eye.
So concrete examples for tech might be.
Think of the unique, sleek form factor of a particular smartphone model, the distinct casing design of a piece of wearable tech like a smartwatch, the elegant contours of a smart home speaker, the specific visual layout of a well-known software's graphical user interface, GUI, or even a novel set of icons designed for an app. These visual elements can be just as crucial as the underlying technology in attracting customers and differentiating your product. So, in phase 2, product development and Indian protection, 6 to 18 months. If your product's aesthetics or maybe key UI screens are genuinely unique, novel, visually appealing, and contribute significantly to its commercial value, you should seriously consider applying for Indian design registration. This protects those distinctive visual elements against unauthorized copying or imitation by competitors. The key criteria are that the design must be new or original, not previously published or used anywhere. It must be applied to an article of manufacture, and it must be judged solely by the eye. It protects appearance, not functional features. That's what patents are for.
Okay, and what kind of protection does a design registration offer in India? How long does it last? Is it a complicated process like patents?
In India, a registered design initially offers protection for a term of 10 years from the date of registration. This can then be renewed for one additional period of 5 years. So you can get a total of 15 years of exclusive rights over that specific visual design.
And what does that exclusive right mean?
It means you can prevent others from manufacturing, selling, importing, or using products that incorporate your registered design or a fraudulent or obvious imitation of it. It gives you a monopoly over that specific look. The registration process itself is generally faster, less complex, and less expensive than patent registration. You file an application with drawings or photographs clearly showing the design from various angles. If it meets the criteria, novelty, originality, etc., it often gets registered within roughly 6-12 months, assuming no major issues. Now, moving into phase 3. International expansion and protection, 18 to 36 months for designs. Similar to trademarks, the Paris Convention priority applies. It gives you 6 months, same as trademarks, shorter than patents, from your first Indian filing date to file corresponding design applications abroad without losing your initial priority date.
So that 6-month window is crucial if your product's visual appearance is a key selling point in global markets.
Absolutely. It allows you to secure international rights based on your initial Indian application, protecting you against intervening disclosures or filings by others during that period. Furthermore, for streamlining international design filings, there's another WIPO-administered system, similar in concept to Madrid for trademarks, the Hague system for the international registration of industrial designs.
The Hague system, how does that work?
This system currently covers approximately 90 countries, including major markets like the US, EU, Japan, Korea, UK, and Switzerland, though notably not China or India currently, but they might join. It allows you to file a single international application in one language with one set of fees to obtain protection for your design in multiple designated member countries simultaneously. This can significantly streamline the international filing process for aesthetics, making it much more efficient and potentially cost-effective than filing separate national applications directly in dozens of countries, especially if you need protection in many Hague member states. If your key markets aren't in Hague, or you prefer direct filing, you can still pursue individual national design filings in those countries. Finally, in phase 4, growth, enforcement, and exit strategy, 36+ months. Just like other forms of registered IP, industrial designs can be recorded with Indian customs to enable border enforcement against imported infringing goods.
So customs can stop look-alike products at the border.
Potentially, yes. If someone tries to import products into India that copy the protected visual design of your product, e.g. counterfeit phone casings that look identical to your registered design, having your design registered with customs authorities can help them identify and seize those infringing goods before they flood the market. For a hardware startup, especially one facing knockoffs, this is another powerful layer of protection for maintaining your brand's distinctiveness and market share.
Wow, this has been incredibly detailed. We've really walked through each major type of IP patents, trademarks, copyrights, trade secrets, industrial designs across the entire startup lifecycle, from that first idea right through to global expansion and potential exit. But as we've been talking, it feels like there are some overarching threads, some common strategies or operational pillars that run through all of this. Things like how you actually pay for all this IP work, and especially what incredible government support seems to be available, particularly for Indian startups. These aren't tied to just one specific IP type, but sound absolutely crucial for the entire journey.
Precisely. You've nailed it. These are the operational pillars supporting your entire IP strategy. They are absolutely essential at every single stage, cutting across all the different types of IP we've discussed. They're like the scaffolding that enables your IP castle to be built strong and maintained effectively over time. Let's start with budgeting, legal counsel, and government support, because these are ongoing considerations right from day one. For your legal budget for IP, it's vital to plan your spending strategically by stage. Initially, for a bootstrap startup in phase one, you want to keep filings lean, focusing maybe on getting those priority dates locked down cost effectively. For instance, as we mentioned, filing a provisional patent application in India might have statutory fees around 1,600 to 8,000 euro thousand. Trademark filings might be around 2,000 euro, 3,000 after the startup rebate. These are the government fees, but remember, attorney fees for drafting and advice will be additional, though potentially minimized initially using facilitators.
Those statutory fees, especially with the rebates, sound surprisingly low. It almost makes formal IP protection feel accessible right from the start, which I think often isn't the perception many founders have.
They are remarkably low, and that's a deliberate policy choice by the Indian government to encourage innovation and make IP accessible for startups. It's a huge advantage. However, as the startup grows, proves its concept, maybe raises funding, and starts seriously considering international expansion in phase three, you need to plan and allocate significantly more budget. International filings, especially for patents in major jurisdictions like the US or Europe, can be considerably more expensive, easily running into several $1,000s per country just for filing and initial prosecution, plus translation costs and foreign attorney fees.
So it's definitely a scaling budget, not a one-time fixed cost. It needs careful planning and prioritization based on market strategy.
Exactly. Which brings us directly to the government schemes, which are a genuine game changer for Indian startups. The very first, absolutely indispensable step for any eligible tech startup in India is to obtain DPIT startup recognition.
DPIIT recognition. How do you get that, and why is it so important?
It's actually a relatively straightforward, free online enrollment process through the Startup India portal, assuming your startup meets the eligibility criteria like age, turnover, innovation focus. And it's incredibly important because it unlocks a wealth of benefits specifically designed to support startup IP efforts. Indian startups absolutely should not ignore this.
Okay, a free enrollment that unlocks a wealth of benefits. That sounds like a complete no-brainer for any eligible Indian tech startup. What kind of benefits are we really talking about here, and how substantial are they?
The benefits are truly transformative, especially for cash-strapped early-stage companies. For patents and trademarks filed in India, as we've touched upon, you get fast-track examination options to speed up the process significantly. And you get those major fee rebates. An 80% rebate on official patent fees and a 50% rebate on official trademark fees. This drastically reduces the direct government costs of securing your core IP in India.
80% on patents. That's huge.
It is. But beyond the fee rebates, and this is truly exceptional support, DPIT-recognized startups can leverage government-empaneled IP facilitators through the scheme for startups' IP protection.
As IP facilitators, what do they do?
These facilitators are registered patent agents or trademark attorneys. Under the SIPP scheme, they can actually handle the professional aspects, the drafting and filing of your patent and trademark applications, essentially for free from the startup's perspective. The government pays their fees directly for these services up to certain limits. This means a recognized startup's professional costs for getting their initial Indian patent and trademark applications drafted and filed can be virtually eliminated. The startup only needs to pay the statutory government fees, which, as we just noted, are already heavily rebated by 50–80%. This removes a massive financial barrier.
Wow. Free legal help for filing, plus huge fee discounts. That's incredible support. Are there other financial benefits?
Yes. Then there are the patent reimbursement schemes. After your patent has actually been granted, you can apply for reimbursement of certain costs. The DPIT's SIPP scheme also has a patent filing reimbursement component. This can reimburse up to 1 lakh for granted Indian patents and up to 5 lakh for granted foreign patents, covering filing fees and potentially attorney costs incurred. There's also a similar MSME innovative patent scheme run by the Ministry of Micro, Small and Medium Enterprises, often with comparable reimbursement figures. And on top of that, some state governments have their own startup policies with even more generous IP support. For example, schemes in states like Kerala or Karnataka have been known to reimburse up to 2 lakh per granted Indian patent and sometimes a remarkable 10 lakh for granted foreign patents.
The sheer scale of that potential government support, free facilitation, massive fee rebates, and then substantial reimbursement after grant is truly transformative for Indian startups. It seems like it could fundamentally change the economics of building an IP portfolio. For a founder facing tight budgets, though, how can they best navigate the application process for these reimbursement schemes to ensure they actually receive those funds without getting lost in red tape?
That's a very practical concern. While the support is phenomenal, diligence and good record keeping are required from the startup side. The process generally involves submitting the required application forms after your patent has been granted, along with detailed proof of payment for all the fees, both government and attorney fees, you incurred during the process. It's often handled through the same SIPP facilitators who help with the filing, or through direct application portals of the respective government department, DPIIT, MSME, or state agency. Maintaining meticulous, organized records of all invoices, payment receipts, and correspondence related to your IP filings is absolutely critical for a smooth reimbursement claim.
So work closely with your IP counsel or facilitator on the paperwork.
Definitely, especially if they are a government-impaneled SIPP facilitator, as they will be very familiar with the exact documentation requirements, eligibility criteria, and timelines needed for successful reimbursement. They can guide you through the process. There are also other helpful schemes and resources to be aware of. For instance, you can utilize WIPO's Technology and Innovation Support Centers, TICs, which have several branches hosted within institutions across India. These centers often offer free access to patent databases, assistance with conducting preliminary searches, and general information on IP, acting as a crucial educational resource for startups just starting their IP journey. Now, even with all the support, engaging your own trusted IP counsel remains paramount throughout the life cycle. They are your strategic partner, not just a form filler.
So even if you use the free facilitators initially,
Yes. Engage an experienced IP attorney or patent agent you trust early on. Many excellent ones are also on the Startup India Facilitator panel, making access easier. But their role goes beyond just filing. Early counsel ensures your overall IP strategy aligns with your business goals, that filings are well crafted for maximum protection, not just filed, that you navigate international complexities correctly, and that costs are optimized by prioritizing filings and smartly leveraging all available schemes. They provide the strategic overlay. For managing the growing complexity, especially deadlines and monitoring as your portfolio expands, consider outsourcing certain tasks using IP management software or specialized services.
what can those do?
These tools can automate the critical task of docketing, tracking all those deadlines for renewals, annuity payments, responses to office actions. They can also provide automated watch alerts for potentially infringing patents or trademarks filed by competitors. This helps you stay organized, prevents those accidental losses of rights due to missed deadlines we discussed, and frees up founder time. It's often a worthwhile investment in efficiency and risk mitigation as you scale. Also, maintaining good government relations and continuous learning is smart business. Stay abreast of any new IP policies or laws coming out of India, like potential updates to the national IPR policy or new regulations concerning data privacy, AI, or genetic resources, which might impact your specific tech sector. Participate in IP awareness programs, workshops, or seminars offered by WIPO, the Indian Patent Office, IPO, or industry associations, and make use of the excellent resources available on the WIPO and IPO websites, like WIPO's IP diagnostic tool for businesses, to continuously identify new IP opportunities within your startup and periodically review and update your overall IP strategy as your business pivots or evolves. IP strategy isn't static.
This brings us back full circle to something you mentioned right at the start, but it feels like it bears repeating because it applies to every single type of IP we've discussed, from patents right through to trade secrets.
Yeah.
The absolutely critical importance of meticulous documentation.
Absolutely. It cannot be overstated. Throughout all phases of your startup's journey, maintain meticulous records and legal documentation. This means keeping organized files of everything. All your invention assignment agreements, your NDAs, your vendor contracts with IP clauses, your licensing agreements, if any, clear records of R&D, and copies of all your IP filings and correspondence with IP offices. This meticulous record-keeping strengthens your claims immensely if you ever need to enforce your rights, defend against challenges, conduct due diligence for funding or acquisition, or accurately value your company. Without a clear, organized paper trail or digital trail, even the strongest underlying IP can become difficult or expensive to defend or leverage effectively. And one last crucial point about strategy. Remember that this roadmap, while comprehensive, needs to be flexible. Startups pivot. It's in their nature. If your business direction changes significantly, you must reevaluate your IP portfolio and strategy. Meaning, you need to decide which existing IP assets are still core and worth maintaining and paying for, and which ones might now be less relevant and perhaps should be allowed to lapse or even sold off. Don't blindly continue investing time and money in protecting IP that no longer aligns with your core business direction. That's just a waste of precious resources that could be better deployed elsewhere.
So the ultimate goal here isn't just about collecting IP certificates like trophies, is it? It's not about having the biggest stack of patents, trademarks, or copyrights just for the sake of saying you have them.
Exactly right. That's a common misconception. The goal is to build and maintain a balanced, strategic IP portfolio that grows intelligently with your company. It's about actively and cost-effectively protecting your core innovations and defining brand elements both in India and key international markets, all while intelligently leveraging the incredible government support available, especially in India, to manage those costs. It's not just a defensive shield, it's about actively building long-term business value, enhancing your startup's valuation for investors or acquirers, creating barriers to entry for competitors, and ultimately contributing to a truly defensible, sustainable, and valuable business for the future. IP should be a core part of your business strategy, not just a legal footnote. Hashtag outro.
Okay, so here's where it gets really interesting when you pull it all together. We've journeyed through this entire detailed IP management roadmap designed specifically for an Indian tech startup. We went from those very first sparks of an idea, through product development, securing protection in India, expanding globally, right up to thinking about enforcement and exit strategies. We've seen how patents protect your breakthrough innovations, how trademarks build and shield that crucial brand identity, how copyrights secure your valuable creative works like software code and content, how trade secrets guard your confidential know-how, that secret sauce, and how even industrial designs protect the unique aesthetics of your products. It's really a comprehensive framework that emphasizes proactive strategy over just reactive damage control. It feels like it's about turning these legal considerations into genuine competitive advantages.
Yeah, and if we connect all these pieces to the bigger picture, it becomes abundantly clear that IP isn't just some legal formality you have to deal with or a departmental checkbox to tick off. It's truly a strategic asset right at the very core of your business model, especially for a tech company. Proactive IP management, identifying what you have, protecting it smartly, monitoring the landscape, and diligently leveraging the incredible government support available in India, plus the global systems like PCT and Madrid, it directly contributes to your startup's valuation. It impacts your ability to attract vital investment, and ultimately, it underpins your long-term success and competitive edge in what's often a very crowded global market. It's really about building a robust, defensible, and valuable business from the ground up, creating an asset that actually grows in value as your company innovates and scales.
So what does this all mean for you, the listener? Whether you're actively building something new right now, maybe scaling an existing venture, or even just kicking around your next big idea, consider this. How might neglecting a seemingly small IP step today, maybe delaying that provisional patent filing just a bit too long, not doing a proper trademark search before launching the brand, or forgetting to get those robust NDAs signed by key partners? How might that impact your company's valuation, its ability to raise that critical next round of funding, or maybe even its very survival, say, 5 years down the road? What aspect of your unique innovation or your carefully crafted brand are you potentially leaving unprotected and thus vulnerable to competitors right now? It's a provocative thought to mull over.
Absolutely. We really encourage you to revisit the concepts we have discussed today, maybe dig a little deeper into the specific government schemes or international treaties that seemed most relevant to you. And most importantly, start critically thinking about integrating this into your own business strategy right from the start. Because knowledge is always most valuable when it's understood and then actively applied to your specific context and goals.
Thank you so much for joining us on this deep dive. It's been fascinating.
It has. Until next time, keep learning and keep innovating.